Most law firm owners have spent years and sometimes decades building their practice. But if someone asked you right now, what is your firm worth? Could you answer it? Not a guess, an actual number. Today, we're gonna fix that. I'm gonna walk you through exactly how buyers value law firms, the distinction that can cut your firm's valuation in half, and 5 specific things you can start doing this month to increase what your practice is worth. Whether you're planning to sell next year or not for another 20 years, this matters because understanding your value changes how you build. Here's something I see all the time with law firm owners. They know what they built last year, they know their profit margin, but they've never actually calculated what their firm would sell for. And that's a problem for a few reasons. First, life happens. According to data from small business closures, 75% happen because of poor management and a lack of systems. I've seen attorneys have to step away from practices due to burnout, illness, or family emergencies. When there's no transferable value built in, there's often nothing left. Next, even if you never sell, building a firm that could be sold gives you something incredibly valuable, and that's your freedom. You stop being trapped in a business that only works because you're holding it together. And third, the metrics that make your firm valuable are the same metrics that make it profitable day to day. So understanding valuation isn't some academic exercise. It's a roadmap for running a better practice. Now, if this is a topic you want to learn more about, make sure you like this video and share with a friend, and please subscribe. We frequently release videos on topics that help business owners like you build a better business and allow them to achieve their goals both financially and personally. So let's get into it. Before we get into the numbers, let's address something that a lot of attorneys wonder about. Can you actually sell a law practice? Now, I want to be clear that I'm not a lawyer, and anything we're going to talk about should be validated with your own bar association to make sure that it's still applicable when you're researching for yourself. The short answer is yes. There are specific rules that govern how it works. Up until about 1990, selling a law practice was essentially considered unethical. Clients were viewed as belonging to the attorney and not transferable assets. That left retiring solo practitioners with nothing to sell, while law firm owners could get paid out. And that changed with ABA Model Rule 1.17, which now explicitly allows lawyers to sell practices, including goodwill, under certain conditions. And here's what the rule requires. First, the seller must stop practicing in the area of the law they're selling. You can transition to help the buyer during a handoff period, but you're exiting that practice area. Second, you have to sell the entire practice or the entire practice area. You can't cherry pick your best clients and dump the rest. And third, this might be the most important, every client must receive written notice of the sale, the identity of the buyer, and the right to choose a different attorney. If a client doesn't respond within a set period, usually 90 days, the consent is presumed. And fourth, you cannot raise fees just because of the sale. The buyer has to honor existing fee arrangements. Now, there's another rule that significantly impacts law firm sales, and that's ABA Model Rule 5.4. And in most states, non-lawyers cannot own law firms. That means your buyer pool is limited to other attorneys and law firms. Arizona eliminated this restriction in 2020, and Utah has a sandbox program allowing alternative structures, but in most of the country, you're selling to other lawyers, which affects both who can buy and potentially how much they can pay. This legal framework matters for valuation because it means clients can walk when you sell. They get notified and then they have to make a choice. So that makes the distinction between personal and practice goodwill even more important because transferable value is the only value that survives client notification. All right, let's get into the actual numbers. There are few common methods used to value law firms, and most appraisers use more than one to triangulate a range. Method 1 is a revenue multiple. This is the simplest approach. You're going to take either your last year or your next year's revenue and multiply it by a factor typically between 0.5 and 1.5 for this industry. So a firm doing $1 million in revenue might be worth anywhere from $500,000 to $1.5 million using this method. The problem with this methodology? It completely ignores profitability. A firm with razor-thin margins gets the same treatment as one with healthy profits. That's why this is just usually a starting point. Method 2 is seller's discretionary earnings. Now, this is the most common for small to mid-sized law firms and other small businesses, to be honest. Now, seller's discretionary earnings, or SDE, represents the total financial benefit the business generates for its owner. You take net profit and you add back owner compensation, interest, taxes, depreciation, and any other discretionary expenses. Then you take that number and you apply a SDE multiple to it. similar to the revenue multiple, but now we're talking about profitability and earnings. Law firm valuations typically range from 2.5 to 4 times SDE. So if your firm generates $400,000 in SDE and receives a 3x multiple, you're looking at a $1.2 million valuation. And that's a 3 is an EBITDA multiple. For firms, say $25 million in revenue and above, buyers often use EBITDA multiples, and these typically come out in the range of 2.5 to 3.5 times EBITDA. Now here's what determines where you fall in those ranges of multiples. And this is where most law firm owners get it wrong. This is the single most important concept in law firm valuation, by the way, and it ties directly back to what we covered about Rule 1.17. Remember, when you sell your practice, every client gets notified. They can stay or they can walk. That makes the type of goodwill you built absolutely critical. And there are 2 types of goodwill: personal goodwill and practice goodwill. Personal goodwill is the value tied to you as an individual, your expertise, your relationships, your reputation. When clients say they hired the lawyer, not the firm, that's personal goodwill. Practice goodwill is the value tied to the firm itself. Brand recognition, established procedures, trained staff, referral networks, documented systems. And here's the critical part. Practice goodwill is transferable. Personal goodwill is not. And as one valuation expert put it, goodwill, if there isn't any value in it, flows from the ability of the seller to successfully transfer a book of business to the buyer. Think about it this way. When clients get that required notice letter saying you're selling your practice, what happens? If they shrug and say, okay, I trust whoever's taken over, that's practice goodwill. If they panic because they wanted you specifically, that's personal goodwill. And that personal goodwill might just walk out the door. So the uncomfortable truth, many law firms have a lot of personal goodwill and very little practice goodwill. These firms have far less transferable value than owners realize. So the question you need to ask yourself is, if my clients got a letter tomorrow saying I was selling, how many would stay? Beyond the goodwill question, buyers are analyzing very specific metrics. And knowing these helps you understand exactly where to focus. Let's start with realization rate. This measures how much billable work actually makes it to client invoices. The average law firm is about 88%, meaning firms leave 12% of potential revenue on the table. So a firm with 95% realization is worth a lot more than one with 80%. Higher realization signals stronger billing practices and better client relationships. The next is collection rate. Buyers look at your effective collection rate as a key indicator of cash flow predictability. Firms with collection rates above 95% command premium multiples because they convert work to cash reliably. The next is client concentration. If 40% of your revenue comes from one client, that could be a red flag for a buyer. Buyers want diversified revenue because concentrated client bases represent risk. Next, let's go to profit margin. Mid-sized law firms typically net profit margins between 25 and 35%. Margins below that invite tough questions about operational efficiency. So what's the good news? These are the same metrics that drive profitability. So improving them doesn't just increase your valuation, it makes your firm better to run right now. All right, let's talk about what you can actually do. Here are 5 strategies to increase your firm's value, and you can start on most of these this month. 1. Shift from personal to practice goodwill. This is the biggest one. Start building systems and processes that don't depend on you. Document your workflows, create client intake procedures that any qualified attorney could follow, and build a brand identity that exists beyond your personal reputation. When a potential client asks to hire you, but is content when you assign another attorney to the matter, that's practice goodwill being built in real time. 2. Invest in technology and systems. A McKinsey Global Institute report found that existing technology could automate around 23% of a lawyer's workload, and lawyers spend nearly 40% of their day on tasks other than practicing law. So firms with strong technology infrastructure and documented procedures command premium valuations. Why? Because they're transferable. A buyer can step in and the systems keep running. Case management software, automated billing, client portals, these aren't just operational improvements. They're value builders. 3. Diversify your client base. Revenue concentration is a valuation killer. If one client could walk away and take 30% of your revenue with them, that risk gets priced into your multiple. Focus on building multiple revenue streams and reducing dependency on any single client relationship. 4. Track and improve your key metrics. Start measuring your realization rate, collection rate, and profit margins by practice area. What gets measured gets managed. And if your realization rate's at 85%, set a goal to get it to 90%. If your collection rate is lagging, implement better follow-up systems. Every percentage point improvement shows up in your valuation and your day-to-day cash flow. 5. Start succession planning early. One consultant noted that by the time a shareholder reaches 65, it's way too late to start thinking about succession planning. The conversation should start at 50 or earlier, with planning implemented over the years. Why? Because building transferable value takes time. The relationships need to shift, the client introductions need to happen gradually, and the systems need to be tested. Don't wait until you're ready to exit to start building a firm that's worth buying. Whether you're 5 years from retirement or just getting started, understanding what drives law firm value gives you a framework for building something that works, with or without you. The firms that command premium valuations share common characteristics: consistent financial tracking, diversified client bases, documented procedures, strong technology infrastructure, and intentional efforts to build transferable goodwill. Start by getting clear on your numbers. Know your realization rate, your collection rate, your profit margin, and your client concentration. If those metrics are strong, you're building value every day. If they need work, now you have a roadmap. Now, if you're looking for help getting your financial house in order, whether that's building better systems, understanding your true profitability, or planning for what comes next, that's what we do at Proseer. The link is below to reach out. We love to help. That's all for today's episode. Make sure you like and subscribe, and we'll see you soon. Thanks.